Welcome all. I'm Deborah Rohde, the director of the Center on the Legal Profession. And let me begin with a brief thank you to our co-sponsors, the Constitutional Law Center, and especially Professor Michael McConnell and Chas Taylor, the executive director, the Federalist Society, the American Constitution Society, and the executive director of our center, Jason Solomon. And I'm going to make a brief shout out to Divine Intervention that made the timing of this panel particularly fortuitous. This was planned months ago to accommodate our speakers' busy schedules, and we just made an educated guess and kept our fingers perennially crossed. And, you know, it took a lot of public servants to cooperate in making impeachment coincide with today's event. So we're happy they did, and especially happy that our keynote speaker, Professor Philip Bobbitt, our leadership speaker for the year, is here to join us. He is the Herbert Wechsler Professor of Jurisprudence and Director of the Center on National Security Law at Columbia Law School, and a distinguished senior lecturer at the University of Texas. He's a fellow of the American Academy of Arts and Sciences, a former trustee of Princeton University. He's served in all three branches of government during 7 administrations, most recently as a member of the External Advisory Board of the CIA. He's published 10 books, chiefly on American constitutional law, nuclear strategy, and the history and evolution of the state. In 2018, he released a new edition of his book, co-authored with Professor Charles Black, Impeachment, a Handbook. And on a personal note, permit me to add that I have known Philip since we were classmates at Yale Law School. And in the decades of friendship that have followed, there's no colleague for whom I have greater respect or affection. He's taught me more on more subjects than I can begin to recount, has offered more support than I can begin to express. And it's nice to have just one public occasion to say how much that's meant. So, Philip.
Can't really thank someone for an introduction like that. It's a sort of introduction that you put in your pocket and you keep there. And sometimes when you want luck or you're in a tricky situation, you feel for it and it comes back to you. And I'm very grateful for it. I want to be very informal today. I prepared just a few notes, most of which I have to say is either something you already know or something with which you will strongly disagree. So we'll go for about 20 minutes with me, and then McConnell and Kesler will have at it with me for a while, and then I hope we have a similar amount of time for questions and debate from the floor. Let me start with the basics of impeachment. As everybody here knows, the House impeaches by a majority vote. The Senate convicts by a 2/3 vote. If the Senate convicts on one count, no matter how many counts of the bill of impeachment, it immediately goes to a different subject, and the consequences of a conviction, removal from office, become the subject of debate. These are roughly correspondent to the grand jury and the petit jury, but only roughly because impeachment is not a criminal proceeding. The Chief Justice presides. Itself is a prior rule. Then the overturning vote has to be by a 2/3 majority or 67 votes. So some of that turns on what the Chief Justice says he's doing, whether he is making a new rule and interpreting it or applying an old rule that requires a higher bar. The text, let's see, maybe we can turn this up a bit. No? Let me see. Or I can try let me try a lavalier mic. I tell my students, I know how I'm going to die. Go get London. I'll be at the theater.
How we doing now?
Let's try that. Anyway, I'll be at the bar. I'll have a heart attack. I'll slip silently to the carpet, and my voice will be so soft I can't tell anybody to get help. Brits will just step over me, and I'll just expire. Is that really any better? Yes. Oh, good. All right. None of the things I've said already are things that you didn't know. So let me just go from there. Chief Justice presides, the House indicts, the Senate acquits or convicts. The text that apply to the subject of impeachment are relatively spare. Article 1 has 3 sections that are applied, clauses 5, 6, and 7 of Section 2. 5 gives authority to the House, 6 to the Senate, 7 simply permits a subsequent trial of the president once he has been removed from office. Article 2, Section 2 prohibits pardons. Section 4 gives the grounds of impeachment, which I suppose will be much of the subject we'll talk about today. And Article 3 specifies that there is no trial by jury for an impeachment. The text and the history behind impeachment, which we can discuss later, are probably the most important sources of our understanding. But there are some important precedents. Impeachment is rather rare. We've had only 18 impeachments of federal officials since our founding, only 9 convictions. No president has ever been convicted, and only 2 presidents have been, and now 3, have been impeached by the House. But there are some precedents we can apply. For example, if the term of the House should expire, the House not being a continuing body, an impeachment adopted by the old House continues into the new House. That would not be true of ordinary legislation. The Vice President cannot vote in an impeachment. There is no double jeopardy with impeachment. So if you're convicted of bribery and impeached and removed from office, you can still then be tried for the crime of bribery. As I mentioned, there are no pardons, and as I never thought I'd have to add, there are no self-pardons. Despite the clarity of these ideas, there are a half dozen fallacies against which Charles Black struggled in the 70s, and I continue the fight that seem almost undieable. The first of these, which you often hear, is that impeachment is a political and not a legal proceeding. If I hear that by John King on CNN one more time, I'm going to actually reach into the box itself and strangle him. Everything the Constitution has to say about impeachment tells us that it is a legal proceeding and not a political proceeding. Federalist number 65 by Alexander Hamilton is devoted entirely to this subject and how we can make it lawful rather than political. The oath that each senator takes, a special oath administered by the Chief Justice just for impeachment, insists that the trial be conducted and decided by impartial senators who apply the law and the Constitution. The text I was just referring to, the various parts of the text that refer to impeachment, all emphasize the legal nature. The Senate must try the matter. A judgment is rendered. Punishment is meted out. These are not issues that we talk about with respect to legislation when we're discussing political matters. The second idea, a little wilder than the first, but still held by some. I heard Congressman Maxine Waters the other day repeat this idea. I first came across it when then Minority Leader Gerald Ford used the phrase about the proposed impeachment of William O. Douglas. Ford is supposed to have said, any honest answer would say that an impeachable offense is whatever a majority of the House says it is. This is nonsense. It's not too hard to show that's true. For example, the text of the Constitution forbids a religious oath for office, religious test. Could we impeach a president because he's a Catholic? Of course not. Does the text say the president may be removed whenever one half the House or two-thirds of the Senate want to do so? Of course it doesn't say that. It goes to great lengths to specify legal causes. So please put that out of your mind. Of course, it's true that people in authority may disobey the law. That happens in every society. The fact that we can say they are disobeying it means we have some idea of what it would mean to follow the law. Sometimes it's maintained that the framers wanted the House to have that kind of leeway, and therefore they used the phrase high crimes and misdemeanors, which I saw a famous commentator the other day said was, I think it was David Lenhart of the New York Times, was intended to be vague. I think there's nothing to this. We know how this phrase came about. When the framers were discussing in Philadelphia the legal causes for removal of the president, and they specified bribery, having in mind the notorious bribery of Charles II and James II by Louis XIV of France, and treason, having come through a war where there was treasonous activity and there were agents still in America of foreign powers trying to suborn officials. George Mason of Virginia said that these two ideas didn't encompass the full range of reasons for which we would want to remove a president. Bribery requires a certain intent, because a political figure may have, as we all have for most of our acts, mixed motives, and may do something he would already have done anyway without the enticement. Treason, in this context, only applies in warfare. Unless the U.S. is at war, a president or other federal official cannot commit treason and therefore cannot be removed for treason. And Mason said there are just too many other reasons for us to say that the president is unfit to remain in office. He suggested the term maladministration. James Madison, who'd been one of the advocates for an impeachment provision, objected to this and said it was too broad, that it would mean a new sort of parliamentary system in the place of the one we were creating, a system by which the president served at the pleasure of the Senate. Mason withdrew this suggestion and suggested in its place high crimes and misdemeanors. To understand the phrase high crimes and misdemeanors, those three words that many have found so elusive, you have to pay more attention to the two words that precede them. Words so mundane that we skip over them. Those words are and other. Charles Black, the great creative constitutional genius, of course the greatest of my lifetime, referred us in the book that we have published together, referred us to the Latin phrase eustum generis. You can imagine what that means, eustum other, generis, the same thing, generic, that's the basis of the word. An example I give when I'm teaching this to my students is I say, suppose I said we're going to have a party for the students this afternoon. I want you to take my credit card and go out and buy some beer and some chips and some salsa and other things like that. And you come back with a Corvette, I'll think you didn't understand the concept of eustum generis. We want to know what is it that treason and bribery have in common that is essential to the construction of the phrase high crimes and misdemeanors. And we'll talk more about this. A third fallacy is that a crime is required. One can easily imagine crimes that are not themselves impeachable. And I've often heard, in fact, I've heard Professor Dershowitz and Professor Turley suggest as much, that an ordinary statutory violation of the federal criminal code is required to trigger impeachment. It's rather simple to think of counterexamples. The one Charles gives is, suppose a president moved to Saudi Arabia so he could have 4 wives. That's not a crime, but surely we would not think a person fit for office who would engage in such wanton dereliction of duty. Suppose a president became insane. That's not a crime, but he would be capable of doing such damage to the state that we would want to remove him by legal authority. Another popular idea is that sitting presidents can be indicted. I've debated this with Professor Tribe, and I remain unconvinced. If I had to just give one reason, putting aside the Federalist Papers and putting aside other reasons I'd like to marshal, I'd give you just a name. I don't know if anybody here is old enough to remember Jim Garrison. Jim Garrison was a district attorney in New Orleans, and I would just remind you that we have several thousand district, county, and municipal attorneys. If every one of these could indict a sitting president and drag him before a grand jury and subpoena documents, we'd find it very hard to run this country, or harder even than we find it now. Another idea is that impeachment is the same for all officials, that we would impeach federal judges for the same reasons we impeach presidents. And finally, an idea that I think you may see discussed. A colleague, a friend of mine said this and has written me, asked me what I think of the idea. I haven't written him back, but I'll tell you what I think of the idea. The notion is that the Senate was chosen rather than the Supreme Court because it is a political body and not a juridical body. Sounds plausible, perfectly reasonable. We just know it's not so. There's a long exposition by Hamilton on why this choice was made. And the idea was that if the president were impeached and convicted and then subject to indictment, that if he were convicted of a common crime, the appeal from that conviction could go to the Supreme Court. And the framers wanted the Supreme Court available for that and not forced to recuse themselves. So they took the Supreme Court off the table. And the balance of 66 is devoted to saying how the Senate can overcome its political nature and act as a court, act in its judicial character, Hamilton tells us. All right, those are elements of a quick sketch of the background. Let me move to current affairs. The president has been indicted on 2 counts, abuse of power and the obstruction of Congress. Now, abuse of power is a little tricky. I hope I can make it clear. If we assume, for the purposes of our discussion, that the president has withheld military assistance from Ukraine in exchange for or seeking or soliciting a promise of political assistance, there are some people, Noah Feldman's a good example, who think that this is an abuse of power, that a president is given power, executive power, to act on behalf of the national interest. When he acts on behalf of his personal or his political interest, he is, by definition, abusing the power he's been entrusted with. I think this goes too far. We constantly organize photo ops with the Queen in exchange for a visit by the Prime Minister to the White House and a photo op in the Rose Garden. This happens countless times. We negotiate trade agreements depending on the timing of the re-election of states, senators from manufacturing or agricultural states. We sign arms control treaties depending on the presidential election coming up. Our officials, elected officials, serve their political interest all the time. So I don't think that quite works. Having said that, I think the basic idea that the president, if it's true, who withholds the expenditure of congressional funds in order to further his personal or political interest is impeachable for that. But it's not because he's acting to better his political future. It's because he's withholding congressionally appropriated funds. If he does that, if he arrogates to himself a kind of super veto, not to follow the law, not to faithfully execute a law, then I think he becomes liable for impeachment. And if he's done so for a corrupt motive, serving his political interest or his personal interest, then I think he could be subject to removal from office. If the allegations against the president are correct, then it looks very much like a replay of 2016. That is, the setting in motion of an allegation against an opponent, perhaps an allegation not even of that great moment, and its constant repetition over months until the opponent appears to be discredited or corrupt. The obstruction of Congress is somewhat weaker on its face because there's no judicial order involved here. There's no order that the president obey a subpoena or subpoena duces tecum, as there was in the Clinton and Nixon cases. On the other hand, it is stronger than in the Clinton-Nixon cases because we have a kind of total stonewalling of the congressional process here. We will encounter over the next few days a debate about evidence. Some people, some of you, may feel that, some of my colleagues may feel, that whatever evidence we turn up on the issues I've just discussed really is not all that bad. It's not all that serious in the big scheme of things, certainly not serious enough to reverse a national election, which was itself of considerable moment. To those who think that, I offer two mild counterexamples, and I understand Professor Carlin has used one of these herself. Suppose the president were authorized by Congress to provide emergency assistance, perhaps in the case of fires in California. And suppose he withheld the disbursal of those monies until local officials here promised to prosecute one of his opponents or to announce such a prosecution. Suppose the president were ordered to disburse funds appropriated and authorized by Congress in the case of a medical emergency abroad, and there was some sort of terrible epidemic on our borders in Mexico. Could the president withhold that assistance until Mexico had agreed to pay for a wall? I think this is inconceivable, and I think it shows just how serious it is. Perhaps in the Q&A we can talk a little bit more about this, and I'd love to see Jack Ruckoff in the audience here. But one of the points I make to my students is that when you move from an aristocracy to a democracy, you have to find ways to keep the attention of the public. The way we do it is by requiring our representatives to come back to the public at least every 2 years and explain why they took money out of your pocket. If you short-circuit that, either through private funding, as in the Iran-Contra affair, or by not spending the money, it's not a trivial matter. It strikes at the very heart of what holds the Constitution to our people. It will be argued, I heard Senator Perdue argue this yesterday, that evidence before the Senate must be confined to the materials gathered by the House. The Senate are not prosecutors. That's true as far as it goes. The Senate are not prosecutors. They are a judge and jury. But you do have prosecutors, the House managers before them, and preventing them from calling witnesses who have important and relevant evidence seems to me a willful act of blindness. Some senators will say that these aren't impeachable unless we need more facts. What I find odd is that so many of the same people are saying we need more facts and that we don't want to collect any more facts. There have been some decisions by the House leadership not to charge bribery, for example, which we may want to talk about, not to litigate. But the decision that seems to have captured our imagination most recently is the Speaker's decision to pause before handing over the articles. Some people believe this was an effort to get leverage against the majority leader of the Senate. I can't believe this. The Speaker of the House is too canny and too smart for that. It seems to me that this was a genuine effort on her part to try to save the Constitution, to give us time to think before we rushed into an acquittal and think about what's at stake. As it turns out, more evidence has come out during the pause, and I'm grateful for that. But I think it was a very courageous act. We've been able to discuss this in the questions. The last 2 points I'll make are these. One is, if impeachment becomes a routine affair, and remember, we haven't had an impeachment of a president until the 70s for 100 years. And before that, no impeachment of a president. Now, in my lifetime, we've had 3. And the intervals between them are getting shorter. We've been able to talk about why this is the case, but whatever the case is, impeachments have the threat of undermining faith in our elections because they overturn a decision by our people. The last point I want to make involves this clip I want you to see, if I can figure out how to do it. Let's see. Here, what am I pushing?
Screw with the mind.
Here we are. And I'll just play this for you. This is a very short, only a minute, perhaps a minute and a half, very short. Speaking before the Judiciary Committee, which she was a young woman from Houston, Texas. She had been the first African-American woman to be in the Texas State Senate. But she was not known to the public knowledge. That changed within the next few seconds. She electrified the country. I'd be surprised if you would do something in her life. This is her opening statement in the investigation of Richard Nixon and the grounds for impeachment.
Today I am an inquisitor, and hyperbole would not be fictional and would not overstate the solemnness that I feel right now. My faith in the Constitution is whole, it is complete, it is total. And I am not going to sit here and be an idle spectator to the diminution, the subversion, the destruction of the Constitution. Who can so properly be the inquisitors for the nation as the representatives of the nation themselves? The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men. And that's what we're talking about.
I'll stop it there. Perhaps somebody may want to go home and finish the opening statement. Barbara had multiple sclerosis. I think but for that, President Clinton would have put her on the Supreme Court. She spent the last years of her life in decreasing paralysis. But she still died unexpectedly. And a few weeks after she died, her long-term partner, Nancy Earl, came to see me. She said that Barbara had kept a little paper constitution in her purse all of her adult life. And that she had said, if something happened to her, that she wanted me to have it. And so Nancy gave it to me, and we said goodbye. I was looking at it, it was just an ordinary sort of thing. You might get it in an insurance company or from your congressman. Really well thumbed, well worn. When a piece of paper fluttered out, it was a ordinary paper like this, on which the types that Barbara couldn't use her hand to write in the last years of her life. And it had been folded over several times. I tracked it down later. It's a translation of a letter from Albert Einstein to Max Borg. And it says, all one can do is try to set a fine example. Stand up for one's values in the company of civics. I think that's a good way to end right now. Then we'll go to some other presentations.
Charles Kesler is the Dengler-Dykema Distinguished Professor of Government at Claremont McKenna College. He's a senior fellow of the Claremont Institute and editor of the Claremont Review of Books. He's written extensively on American constitutionalism and political thought, and his edition of the Federalist Papers is the best-selling edition in the country. He's also the author of I'm the Change, Barack Obama and the Crisis of Liberalism, the editor of Saving the Revolution, the Federalist Papers and the American Founding, and co-editor with William Buckley of Keeping Tablets, American Conservative Thought. Thank you so much for joining us.
Thank you very much. It's a great pleasure to be here and honor to be on the same stage with Phil. This is not my first pass at the impeachment question. In the summer of 1974, in the early summer, as the impeachment of Richard Nixon was proceeding and about it seemed to be consummated by hearings and votes on the House floor, I was a rising freshman at Harvard. That is, I was going to be reporting in the fall, and we had to make a choice of what subjects we wanted to study in our expository writing class. And they gave you a wonderful menu of all kinds of things. You could study science, you could study history, you could study arts, Shakespeare, Moliere. But I picked impeachment because this was the hottest topic of the day. And by the time I reported for duty in early September, of course, it was all over. No impeachment. Nixon had resigned. It was a dead issue. But I proceeded to read all the books written about impeachment, basically at that time, including Charles Black's original edition, the book which Phil has enlarged. And I must say, of all of them, Raoul Berger's book, which was enjoyed a great vogue at the time, of all of them, I thought Black's book was the best. It was simple, straightforward, and yet very deep. It took seriously impeachment, and it spoke as a citizen to other citizens about the issue, not simply as a lawyer or a law professor or even as an academic. So now, strangely, many years later, more than 40 years later, I find myself back in a public forum discussing impeachment. And what Phil has said is so reasonable, I don't really plan to disagree with it. In fact, I think I agree with him much, just about on everything, but with a few questions of emphasis. But let me begin by putting in my own way the point he was making at the end about the prevalence of presidential impeachments in our politics. One could say that in the first 185 years of the Republic, there was one presidential impeachment. That was Andrew Johnson's at the end of the Civil War. In the next 45 years, there have been 3 presidential impeachments, counting Richard Nixon's abortive one. There was Nixon, there was Bill Clinton, and now there is Donald Trump. But there have been rumors of impeachment and threats of impeachment quite frequently in the last 20 or 30 years in American politics. During the Iran-Contra scandal in the latter part of the Reagan administration, editorials were written, political speeches were given on the question of whether Reagan had committed impeachable offenses in the course of Iran-Contra. The impeachment flag was flown also in the George W. Bush administration over the Iraq and Afghanistan wars and how we got into them and whether there was lying involved by the president or others in high public office. And of course, even in the Obama administration, shoes on the other foot, Republicans were talking about impeaching Obama for various things: the Fast and Furious scandal, the Libyan embassy disaster, and many other topics. These did not come to fruition, Reagan, George W., and Obama, but there was, at least for a while, a discussion of impeachment. So impeachment has certainly become more prevalent. It isn't yet a casual recourse of an enraged Congress, but we're moving in that direction, I think. Now, Alexander Hamilton, already mentioned in Federalist 65, was well aware of that danger. He said in 65 that impeachable offenses are in their nature peculiarly, he said, political. Now, Phil says that they're not, or they shouldn't be political, they ought to be legal, but they're always both. And they have to be understood, I think, as inevitably political in a way that ordinary legal proceedings are not. That is because impeachments do proceed from the misconduct of public men, from the abuse or violation of some public trust. Those are Hamilton's words. And he predicted, therefore, that whenever there is a prosecution of presidential impeachment or of any high official's impeachment, the whole community will be inflamed. The passions of the community will be aroused. It will be divided into parties over the guilt or innocence of the person charged, and all pre-existing factions will be aggravated and connected and enlarged by this new question. Now, in times such as ours, which are bitterly partisan and deeply partisan, maybe not unusually so in American history, but in a way that is still, I think, shocking to a lot of us, the danger of the partisan use of impeachment is greater than normal, particularly when liberals and conservatives for almost 100 years have in a way been appealing to two different constitutions in their arguments with one another. Increasingly, as you know, conservative judges, but not just judges, citizens, political parties, have recourse to the original Constitution, the Constitution as originally understood and as amended, the written Constitution, the limited Constitution, as Hamilton calls it in Federalist 78. Increasingly, liberals and progressives hold up the banner of what they have called since Woodrow Wilson the living Constitution, a Constitution that is not bound down so much by the words of the Constitution, but free to evolve with the conscience of judges and the convenience of the community. When impeachment is viewed through two such different lenses, really two competing constitutions, not simply two interpretations of the same Constitution, the danger of the political use of impeachment, it seems to me, grows much larger. Hamilton already, though, foresaw the danger that presidents might be impeached, might be subject, he said, quote, to the persecution of an intemperate or designing majority in the House of Representatives. It ought not to be forgotten, Hamilton cautioned, that the demon of faction will at certain seasons extend his scepter over all numerous bodies of men. That's all from Federalist 65. So for Hamilton, this was a reason to have impeachments tried by a smaller, more select and deliberate body, namely the Senate. The charges could be brought in a larger, more popular body, the House, but the actual trial should be conducted in a more sedate setting in the Senate. But it's also a reason, perhaps, while presidential impeachments, not so much judicial ones, which have been the vast majority of impeachments conducted by the Congress, why presidential impeachments up to this one have always included criminal charges. I agree with Phil that they're not strictly required, but that makes it even more interesting that the impeachment of Andrew Johnson, the impeachment of, or the almost impeachment of Nixon, the impeachment of Clinton, have all specified among the charges brought against them violations of some criminal statutes or another. They weren't all violations. All the violations alleged were not of criminal statutes, but there were always some actual violations of statutes alleged. I think that's because extra caution is needed in bringing an impeachment against the president, because you want to keep them from becoming a routine weapon used by Congress against the one-man executive. You don't need such strict standards if you're impeaching a mere federal judge. There are lots of federal judges. It's not as consequential and, of course, not nearly as political. I think the authors of the Constitution and its defenders over the years have wanted to prevent the separation of powers system in the Constitution from becoming a regime of legislative supremacy, becoming a kind of quasi-parliamentary regime where the president is expected to lead Congress and lead public opinion, but also to rely on the political support of Congress for his own continuation in office. Such a quasi-parliamentary constitution has been on American progressivism's wish list at least since Woodrow Wilson. And the same progressive impatience with the separation of powers constitution and with the independent executive in that system of separated powers is, I think, on display in the impeachment of Donald Trump. It was only yesterday that the New York Times announced with great fanfare what it called its 1619 Project, meant to impugn the founding and the founders as irredeemably racist and to denounce the Constitution as a pro-slavery document, a noxious monument to white supremacy. Anyone who reads the Sunday New York Times received this special edition of the magazine and a whole section of the newspaper announcing this 1619 Project. Now we hear Nancy Pelosi and the New York Times praising the founders' immortal wisdom and justice in providing impeachment as a constitutional remedy for an executive who might otherwise be reelected in 10 months. Reelected by a wayward people, or at least by a wayward and racist constitutional majority acting through the Electoral College. This head-spinning, head-snapping revision in the left's view of the Constitution from an irredeemably racist document of the past, flawed, full of ignorance and superstition, to a monument of wisdom that we are defending against the populist interventions of Donald Trump is remarkable, but of course, I think purely tactical and therefore temporary. I'll end on this thought. What the partisan majority in the House, and there was not a single Republican vote in this impeachment, unlike even the Bill Clinton impeachment, members of his party voted to impeach him. In the Nixon, what would have been the Nixon impeachment, many Republicans voted to, or were prepared to vote to impeach him. This is really the first purely partisan impeachment of a president in our history. And what the partisan majority in the House really, I think, finds him guilty of is seeking to run the executive by his own, sometimes peculiar lights, which are friendly to the original understanding of executive power and hostile on the whole to the shibboleths and superstitions of the administrative state and of modern liberalism. The latter are not impeachable offenses under the old-fashioned, or dare I say, conservative Constitution, but they very much are impeachable under the living Constitution, and it is this struggle between those two constitutions that makes this political moment so interesting and so dangerous. Thank you. Thank you.
And we're on.
All right.
Let's turn back
Good.
off for a sec. It's not quite.
So we're recording this, so it will be up on the Senate's website. So people should go to the sites, which will be rotating for your questions. I'll start off with just one. For a lot of the last couple months or so, the question was frequently aired about whether if the Democrats went forward with what they thought were impeachable offenses, it would come back to bite them in the election. And that's now impeachment, Clinton impeachment, which I worked as a special counsel to the House Committee often ago. There are lots of differences between now and then. And a lot of Democrats, I think, thought it was not entirely clear what the political fallout would be and the relative costs and disadvantages. And in that state of ambiguity, might as well do the right thing, which by their lights, both legally and constitutionally, was to move forward with the impeachment and to also move forward quickly enough to try to get it resolved so that it wouldn't derail the election. And I guess my question to both of you is, do you think that was the right call? And what do you think the political fallout will be from something which I think you both persuasively argue ought to be seen as a legal and constitutional question preeminently?
I want to tell you one of my favorite political stories, maybe my very favorite political story. It was kind of long, so just sit back and relax. Congressman comes back from a fact-finding tour in, I want to say 1949, 1950. Plane lands at what was then called National Airport. They push the little gangway up to the plane, and at the bottom he's met by half a dozen reporters. Comes down, he has kind of an impromptu press conference. One of them says, welcome back, Mr. Congressman. How are things in Europe? Congressman says, well, fine. I was only there for 2 weeks, but I saw a lot of the terrain. And one of the reporters says, how are things in Germany? Congressman says, well, I'm optimistic. In Dr. Adenauer, Dr. Schumacher, you have leaders of both parties that are committed to democracy. We've replaced the Reichsmark with the Deutschmark. So I'm cautiously optimistic. Another reporter says, what about Italy? Congressman says, well, as you know, we've lost to the communists in Milan again, a mayoral election. The government's fallen, but you know, they just really moved the chairs around. The Christian Democrats are going to dominate the next government. We'll have a strong ally in Italy, no matter what the surface appearances are. The Congressman says, what about France? Well, we're going to have to deal with the Algerian problem, you know. At some point, I bet the general comes back, and we'll see what he does. And anyway, I'll try to make this even shorter, but he just walks around the terrain of the principal countries in Western Europe. He even touches on the Soviet Union with very sophisticated answers. And then he says, now, boys, I've got to go home now. I've been away from the missus for a couple of weeks, and thank you for coming out to see me. And one of the reporters says, just one more question, Mr. Congressman. Back in your old home district, just outside St. Louis, there's an election next Tuesday for your old seat in the state Senate. I know it's a close one, but what do you think? Who's going to win? And the Congressman says, well, now, Sonny, that's a difficult question. And that's sort of my take on this, that these are very, very complex questions, much harder than the constitutional parameters of a just and enduring set of impeachment rules. And as Professor Rode said, it's best just to do what you think is the law. Try to follow the Constitution. Don't try to guess about politics. It's too complicated. It's too difficult, even for the shrewdest among us, of whom I am not that person.
Well, I'm a political scientist, so what do I know? I mean, this is I don't have the inhibitions that law professors have. I would say I would not count on the same, supposing that Trump is acquitted. I don't necessarily think that he will have the same kind of positive bounce that Clinton got when he was acquitted. Mostly because Clinton was a lot more likable character than Trump. As a likable rogue, his basic approval was not really endangered by the impeachment nor damaged by the outcome. Of course, much would depend on what happens in the next couple of weeks and how the impeachment goes. But I would say from a political point of view that it's not a big loser for the House Democrats, I don't think, but it's not probably going to be a big winner either.
And on that inconclusive note, let me open it up. Yes.
Thank you. Do you think the ruling today of the GAO can be referred to and will be relevant in the discussion? Maybe you can repeat more authoritatively than I what the ruling was, but
No, you put it very well. The Impoundment Act of 1974 was a statute passed after Richard Nixon had repeatedly, but in one particularly egregious case, withheld funds that had been appropriated and authorized by Congress. I say particularly egregious because it had to do with the rural electrification of my whole part of Texas. A president has the power to veto an appropriation statute, and if the Congress insists that it be law, they have to pass it over his veto. There's also a long history of presidents withholding or deferring the expenditure of funds when circumstances have somehow changed. And the notion is that if Congress had known then what you know now, they wouldn't have passed the statute. Nixon's wrinkle on this was to veto an appropriation, have it passed over his veto, and then just decide not to spend the money. That, I think, is clearly unconstitutional. One of the consequences of this was the passage of this statute. I don't know what effect it will have on impeachment, but I was extremely glad to see that it came at this moment, because I think this is such an important part of the Constitution. We focus, perhaps not wrongly, but we focus a great deal on the Bill of Rights. We focus on electoral conflicts and federalism. But the beating heart of the Constitution is Article 1. You could imply a judiciary. You could imply an executive. Hamilton and Madison thought you could imply the Bill of Rights. But you have to have that central core of legislative power. And impoundment is not a technical flaw. It is a very serious constitutional, I would call it high crime.
can that, because it occurred today and isn't embedded in the articles of impeachment, can it be considered relevant, that ruling of the GAO, that he was actually breaking the law?
Well, I think so. I want to hear what Charles and others think. The reason I say so is because the funds that were impounded were the funds that were going to Ukraine. And the abuse of office count is based on the threat to withhold these funds and the pendency of their withholding as he tried to push around the Ukrainians. So yes, I think it's part of that charge. If your question is, if new evidence came to light of a really egregious nature about some other offense, are we confined to the counts adopted by the House? Yes, I believe we are. You have to go back to the House, get another bill, pass that, and send to the Senate.
Right. I mean, there are 2 points there. I mean, in a trial court, you try the case as it comes to you. You can't add charges. You can't add, evidence that comes to light in the middle of the trial or towards the end of the trial.
Well, sure you can.
Well, you can, but it has to be the judge has to agree to it. And this is a situation where if you're adding new articles of indictment, I mean, I think you have to start over as far as those new articles go. But the other thing is, Congress's budgetary office said this was a violation of the law. The executive's budgetary office said it was not. This is a separation of powers question. It is not it seems to me it's not an impeachable offense. Besides, the funds were eventually spent as Congress had directed. So even if it were an impeachable offense, I don't think it's impeachment worthy today. I mean, it doesn't, with an election 10 months away, I don't think that this is the kind of issue over which one should be indicting and trying the president.
Other questions? Yeah.
It's kind of a two-part thing, but it fits together, I think. Kind of a two-part thing. I want to know what the role is, specifically, Professor Bobbitt, of the House managers, but hold that, witnesses. So the question of if it is opened up to witnesses, and it seems like the Republicans, on the one hand, don't want witnesses, but are threatening to say, okay, if you want witnesses, then there's the specter of Hunter Biden, Joe Biden, and the whistleblower. Well, clearly Hunter Biden and Joe Biden are completely irrelevant. The whistleblower, maybe there could be an argument made by that, but the whistleblower information has been so overridden by other later witnesses. And how it fits together is, I'm wondering, is it the House managers that have some control over this, or is this a ruling by the Chief Justice, or how does this fit together?
Well, in the past, the witness list has been agreed upon between the majority-minority leaders. That seems to be a contentious question now. The House managers are the prosecutors, but unlike prosecutors in an ordinary criminal trial, they can't demand the evidence of witnesses that the Senate bars. And if the Senate were to pass a rule excluding witnesses that the House managers wanted to call, they wouldn't be called. As far as your point about Hunter Biden and the whistleblower go, this sounds callous, and maybe it is a little cruel. I personally would rather see Hunter Biden called and the whistleblower called than we not have testimony from John Bolton and Rudy Giuliani and Mick Mulvaney and some of the persons who clearly are germane. Sure.
I'm so sorry.
I was just saying, perhaps in a criminal trial, a judge might rule irrelevant the testimony of Hunter Biden if we were trying the president for bribery, an ordinary statutory crime. He might rule Biden's testimony, the son's testimony, irrelevant, or the whistleblower is too attenuated since the facts have supported his claims. But for something as momentous as this, especially when our country is so deeply divided, I think you want to bend over backwards to give the other side the witnesses they want and let them present their case. The American people aren't fools. If this is really irrelevant, it'll come out. If the whistleblower is really making it up, nothing to what he has to say, well, that'll come out too. So I said I think that's insensitive because it will destroy these people's reputation. But this is a very, very grave event constitutionally. So that would be my take on it. They're the prosecutors, just like they were prosecuting district attorneys or county attorneys.
Yes.
throughout this whole process, the thing that initially struck me is that it's not a black and white issue. There's a lot of gray area here. And you alluded to the fact that despite the fact that the funds are appropriated by Congress, there is a certain amount of discretion that gets given to the executive branch, that funds are withheld because things changed, et cetera, et cetera. It seemed to me when I first heard this that this has happened all the time, that there's arm twisting, et cetera. There's also a possibility that you don't want to give money to Ukraine because there is rampant corruption and the money wouldn't be spent properly. The fact that Hunter Biden happened to be involved with it, well, that's a political portion of it, but it's not the whole motivation. From a historical perspective, can you explain a little bit more about the discretion involved here in the executive branch?
I'd be happy to try, but you've got the country's greatest constitutional historian sitting here in your second row. Maybe he'd like to come in on this.
Jack, I think he's talking about Jack Rakoff from the Stanford History Department.
If I'm going to do this, restate the question so make sure I have. Just restate your point, so I'm sure you.
I guess what I was setting up is the idea that the money is appropriated by Congress, and yet there is.
Okay, right. So look, I take Phil's point to be that circumstances change over time. Legislation is not always revisited. Laws may be standing, which in a sense have lost their effect. I mean, the principal distinction between that scenario and what's happening in Ukraine is that all the facts and evidence that that justify the grant of military aid, which is a very recent development, are still present. One of the witnesses in the House Intelligence Committee testified very dramatically. Now I forget which. One of the State Department guys in the embassy said, people were dying. Ukrainians were dying in the military conflict between the kind of pro-Russian separatists and the Ukrainians. So that's a pending situation. I mean, that's that's current policy. I mean, I think the fact remains, and Phil can correct or update me on this, but there are specific criminal violations under the U.S. Code, which Trump and his henchmen have been introducing. I mean, including having a foreign government, requesting the assistance of a foreign government in an American election is a violation of criminal law. If the GAO report today is responsible, and from what I know about the GAO, even though it's being lambasted as a kind of democratic front, it's long been regarded as an intensely nonpartisan, extremely professional organization whose basic mission is to make sure that, in fact, institutions of government are carrying out their duties responsibly. I mean, their report this morning, which I only had a chance to glance at, ends with a pretty strong conclusion about really reporting an allegation of bribery on what's happened. So in this sense, maybe unlike Charles, perhaps closer to Phil, I don't see all that much ambiguity here, and I think the fact situation that Phil set up doesn't really apply to the Ukrainian case.
Also, remember that in the statute itself, Congress wrote a provision that DOD had to check off that Ukraine was not so corrupt that they couldn't use the funds and so forth, and the Pentagon made that finding. So I think it's a real stretch for the president to say, I'm not going to spend the money, or I'm going to delay the money. Not spending the money and delaying the money is not so different. You've got 13,000 deaths. It's a very serious matter, and I don't think that the discretionary things I mentioned, for example, you appropriate money for the treatment of a disease, and the disease is cured or something. You have a 20-year program for cancer research and someone solves the problem. I don't think this is like that. I think this was really not executing the law, which I think is very serious. Charles and I may be more overwrought about this than I should be. You'll have to judge. But he did not execute the law, and he did it not because the situation had changed, not something that Congress wasn't aware of. There is this provision I just mentioned. But rather he did it because, if these facts are proven, he wanted to shake down the foreign leader to participate in perverting the course of our election. Good heavens, what does it take with you guys, Charles? This is
Well, I mean, let's recall that under 8 years of the Obama administration, no lethal aid was delivered to Ukraine, despite the fact that they were fighting the Russians and dying in eastern, what was once at least, and may someday be again, eastern Ukraine. This administration signed the law and delivered the money. It didn't deliver it right when Congress now says it wanted it delivered, but it was delivered, and it's only deliverable because the administration agreed to it.
I have to say this goes over my head. I don't understand the relevance of Obama not spending money that wasn't appropriated or authorized by Congress to the question of whether or not Donald Trump is guilty of a constitutional violation of not spending the money that was appropriated and authorized. On the merits, I'm with you. I wanted Ukrainian assistance throughout the Obama administration. But that's the merits of a different question, it seems to me.
I think we have time for one last question, and we haven't heard from any students. So we have a student who has a question. Yes, thank you.
Thank you so much. Thank you both for being here. I have a question for my Claremont friend, since I went to Pomona College. I am curious, you raised, this is less directly related to impeachment than the last question, so I apologize. You raised this argument about the New York Times and the idea of a racist constitution during your talk, and I'm just a little bit confused. I'd like to hear how you play out how Democratic lawmakers are supposed to continue utilizing the Constitution in issues like impeachment if they legitimately believe that the Constitution has racist elements or is in fact a racist document. And as a prerequisite to that, I'd like to just ask whether you think that the Constitution has racist elements or is a racist document.
Well, it's. I was pointing out that it's one thing to impugn the original intent or original understanding, whatever you want to call it, of the Constitution as itself immoral. That is, as a part of a regime of white supremacy. And then to turn to it and raise it as, in a way that I would certainly agree with, as a standard of political right and wrong that we ought to apply, to the extent that it can be applied, to current disputes. That seems hypocritical to me. I mean, to use as it were, the original intent of the Constitution when you want to, but to reject it as unpure.
So should we use
the
original intent of the Constitution in its racist elements today, if you're sure?
Well, I don't think there are certainly parts of the Constitution. I'm not sure what racist element of the Constitution you're speaking of. If you're speaking of the compromises over slavery, undoubtedly there were serious compromises involved, several of them in the making of the Constitution. But the question is, were those compromises in furtherance of a principle in the Constitution, or were they precisely compromises because they violated the deeper principles of the Constitution, which were not racist or white supremacist? That would be the argument I would take. There's no denying that there are, that the Civil War grew out of deep constitutional and political disagreements in the early history of the Republic. Of course not. The question, though, is, was the Constitution and the 13th, 14th, and 15th Amendments, were they a vindication, as it were, of the original Constitution, or were they a replacement, a supplanting it, and for the first time moralizing what had been racist and immoral?
Well, that's a topic maybe that could use elaboration on another occasion, but thank you all for being here to talk about it.